Welcome to the Ojai City Council and Planning Commission joint special meeting, May 13th, 2014. Roll call.
Councilmember Blatz?
Here.
Councilmember Clapp is not here at the moment. Councilmember Lara?
Here.
Mayor Pro Tem Smith is not here at the moment. Mayor Strobel?
Present.
Commissioner Nolan?
Present.
Commissioner Nicklin? Not here at the moment. Make a note that Councilmember Clapp just arrived. Vice Chair Foster?
Here.
Commissioner Zabella?
Here.
Commissioner Jagiello?
Here.
And Chair Merck?
Here.
And did I miss anyone? No. Okay.
Okay, and I'll ask Chair Merck to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Well, I have misplaced my agenda for the special meeting, being the clever person. Here we go. Okay, this will be a workshop session to review the City of Ojai Telecommunications Ordinance. Mr. Clark?
Thank you, Mayor and members of the Commission. The purpose of this workshop is really to kick off our effort to craft a new telecommunication facilities ordinance. And the first step is understanding the regulatory and legal environment in which we operate. So we've invited Jonathan Kramer, who is sitting to the right of Joe Fletcher, our special counsel who's advising us on this matter. And he's going to be making a presentation and then responding to questions from the council, the commission, and the public. So I think at this point I'll turn it over to Mr. Kramer.
Welcome, Mr. Kramer.
Madam Mayor, thank you very much. Good evening. I am Jonathan Kramer. I've got a PowerPoint. If we could go ahead and load that. I promise you this will not be death by PowerPoint. I'm going to take probably about 25, 30 minutes to go through it. And my goal through this presentation tonight for everyone here, including the public, is to talk about what's happening, where we have been, where we are today, where we're going, lay out a roadmap, talk about the potential pitfalls in front of us, and hopefully at the end of this you'll have a lot of questions that will key off of what I've done and your own questions, and I'm here as long as you have questions. I'll also be here tonight during the consideration of the moratorium extension. Not sure where I'm aiming with this. Cool. All right. All right. Many of you already know who I am, but for the rest of you, by way of background, I am actually a radio frequency engineer who, after 20 some odd years of working for hundreds of cities, providing technical information and working with a heck of a lot of city attorneys like this guy right here, said, okay, I know what you guys are doing. You're never going to understand the technology like I do, so my wife one day said, you should go to law school, and I didn't have a good excuse that day. So I'm an RF engineer primarily. I have way too many licenses. I am an expert on RF safety issues as well as transmission, and we'll go on. So before we get into it, I'm going to be using terms tonight, and I'd like to just key on some of the ones that I'll be talking about, make sure that we're all on the same page. Terms of art, microcell. Those are the big cell sites when you're driving down a street. The big sites like the big trees, the monopoles, things like that. They're called macrocells in the business. Smaller technology sites, distributed antenna systems, and small cells. I'll talk a lot about that in the presentation tonight. They are, as the name suggests, smaller sites to provide wireless service. 3G, 4G, those talk about technologies that are currently in place, and so much of what's being driven now is the upgrade from the third generation which basically is separating voice and data to the combination of voice and data on a single service, which is 4G. And now even 5G is starting to come into technical fruition, if you will. The FCC, as you well know, licenses these services. And the FCC also provides for unlicensed services. And let me take the first jab here talking about the new ordinance. When we talk about a wireless ordinance, we're not just talking about the cell companies. We're talking about all of the different types of wireless services. So we'll also be dealing with unlicensed services. FCC authorized unlicensed services will be part of our project to bring them into a coherent regulatory scheme within the city. The CPUC is the California Public Utilities Commission. They license telephone companies in the state, and they also provide regulations that we have to follow as to the use of, for example, the right-of-way. Later on in this process, you'll hear about how the wireless companies have compulsory access to use the right-of-way. It's subject to our time, place, and manner controls. So utilities in the right-of-way also will come into the regulatory scheme here. JPA, probably won't talk that much about it, but JPA stands for Joint Pole Administration. The poles that are in the right-of-way are managed by a group of the users. So the regulations that we'll be crafting will have impact on their uses as well. There'll be other terminology that I'll use as we go through the presentation, but these are some key points just to get us started. And to show you the differences between macro cells and smaller cells, you might recognize the site on the left. It's here in town. And that's a traditional macro cell type site. It's camouflaged, but it's the bigger type of site. And then a small site is that pole and antenna on the right-hand side. That's actually in Rancho Palos Verdes, and that's a cell site that's a very small one. So just to show you some size differences, I'll actually take you on a travel log here later in the presentation to London, England, where I was last week, to show you some even smaller ones. To understand one of the most important concepts that will drive the ordinance, I have to spend a couple of minutes talking about coverage versus capacity. This is a critical distinction for everyone to understand, because as we regulate, these are the critical issues that come up. The coverage issue is basically putting down a signal over an area. If a wireless carrier, and I'll use them pretty much for the balance of this discussion, if a wireless carrier has service in an area, they may have service on all of their authorized bands. So they may be looking at providing new coverage in an area that they already serve. This is important legally because each band that they operate on is separately licensed and they have federal rights to each band. We look at new coverages, we look at existing coverage, but this factors into how the ordinance will be written, and will deal with the issue of whether a carrier has a gap in their service by looking at RF coverage. Now, the other term that we have to understand is capacity. If you look at the top illustration, I'm showing basically one coverage area from one cell site. But as wireless networks deploy more and more sites, they do it because they have a fixed number of frequencies they're allowed to use. So the way that they increase the capacity is to say essentially, okay, we had one site at the top that provided coverage for a particular area, but now what they're going to do is they're going to split it up into, in this example, 3 or 4 sites. Because they do that, they can reuse the frequencies and actually add capacity. What's capacity? Capacity recognizes the fact that most users now have multiple cell phone devices. If you have a family, you have mom, pop, kids, it's very likely that all of them have cell phones. It's also likely that their cars have cell phones built into them. If you have a car that has like a Lexus Connect or Mercedes, all of those, a lot of cars now, the Ford cars have wireless phones built into them, OnStar as an example. Interestingly, every ATM now has a cell phone built into it. And that's because if the ATM gets stolen, it literally calls and says, I'm being stolen. It has a GPS. It says, this is where I'm at, come get me. Coke machines, a lot of vending machines have cell phones in them. Why? Because it's expensive to send someone out to service a vending machine that's full of product. So now, instead of sending someone out to service it, it waits for the machine to call and say, I need some Coke. Come, or my money I've got too much money here, come empty me. So many various services use cellular technologies. So it's more than just cell phones. That's why capacity is the issue. Today, capacity is the big issue. As you know, most areas are served. We had a project recently here in the city, and I'm not going to delve too much into the specifics of it, but that was to add capacity to an existing network as opposed to providing a brand new coverage. So these are the bottom illustration here is what we see a heck of a lot more these days than the top. We're going to take a quick detour and talk about federal law. The federal law that really sets the stage for us is Section 704 of the Telecom Act, and that's codified into federal law at 47 U.S.C. 332. I have highlighted the top section here. And the reason I've highlighted it is because for us, from a regulatory standpoint, the highlighted section, subsection A, the general authority, is the one that gives us the basic authority to do zoning. I'm going to come back to this a little bit later in the lecture, but understand that the source of our federal authority to do what we're doing comes from Section 704 of the Telecom Act. It's the Telecom Act of 1996. Historically here, we have operated under really two sets of regulations. We had one that was in effect from roughly 1998 through 2004, and then our most recent update of the municipal code in terms of wireless was in 2004. 10 years is a heck of a long time, and to give you a framework for understanding what that means, a wireless carrier today, if you say, what's your long-term planning, they'll say 2 years. And it's because of capacity, because people keep on finding new ways to use cellular services. So that's why 10 years is inconceivable for a wireless company, and for a local government, it's a long time for a regulation, for a body of regulations. You've done very well with what you've had, but changes in laws, changes in technology drive the need for this current upgrade. I'm going to have a whole slide just talking about that. The current section is, there are currently 4 major sections of your ordinance: applicability, guidelines, requirements, the conditional use permit, and the removal and abandoned antennas and towers. There are a number of subsections. I'm not going to kill you by going into each one in detail, because frankly, this is what you have. This is not what you're going to have. What you have is a basic set of regulations that has been appropriate, but has grown long in the tooth as the change in technologies. Talking with the city attorney about it, there are a number of things that, even if anything else, even if the world had not been changing technology-wise, he and I would both still want to make some changes to the ordinance to reflect changes in technology, changes in regulations, court rulings. You'll see this as we get going. This is the big slide. This is the slide that's going to have a lot of information, but I'll tell you before I even get into it, follow the bouncing ball. And the bouncing ball here is going to be years. For each of the things I'm about to bring up on this slide, look at the years. It's going to kind of set a big picture. The big picture is the federal regulations that we are subject to, state regulations we're subject to, what we do here in the city, and probably most importantly, the courts, because the courts interpret it. And the court's interpretations have fundamentally changed regulation in California. The Ninth Circuit, where we're located, is a very active court for wireless regulation interpretation. Turns out a lot of the key rules adopted in other circuits around the country have come out of the Ninth Circuit. So let's start this long slide. And as I've been, yes?
Because of Silicon Valley? What do you think the reason for that is?
The Ninth Circuit is how do I put this nicely, Mr. City Attorney? If you want to go to the Supreme Court, you go through the Ninth Circuit, because the Ninth Circuit is an activist court, and I won't say that our esteemed justices are contrarians, but they have a somewhat different view, forward-thinking, they would say. So a lot of the court decisions in the Ninth Circuit have shaped other circuits. A lot of the court decisions in the Ninth Circuit go up to the Supreme Court because the Supreme Court says, oh, they're tinkering in the Ninth again, we better bring it up and kind of fix it and make sure we understand what they're talking about.
So it does not have anything to do with the fact that California has produced a lot of these technologies that have led to this current situation?
It's just the opposite. It's because we're consumers of the technology.
Ah,
The
thank you.
technologies are created, but it's where they're consumed that forces these issues. We are incredibly heavy consumers of these services. Okay. Okay, so 1996, the Telecom Act. This is the framework. I showed you the Section 704. And then 1997, the FCC, acting as a requirement of part of the Telecom Act, came out with their RF safety standards. That I bring this up because this is something that's very near and dear to the hearts of the public. Are these services safe? My personal involvement in that is that I actually co-authored the FCC's Guide to Local Governments on RF safety and how to interpret the rules. The underlying documents are in a language that's not even close to English, so the guidance that the FCC produced helps to translate it. 1998, we have our wireless regs. It's easier to follow how all of this deploys via the timeline, and you'll see how it all interacts. In 2000, that guide I was telling you about was released to local governments. It's called the LSGAC guide. That's the guide that tells local governments what the FCC rules are for RF safety and how they're applied. In 2001, we had a major court case called Auburn versus Quest. It's basically dealt with regulations, how regulations are of telecom services are dealt with, and how they're attacked literally by the wireless and the telecom industries. So for a long number of years, this was a critically important case that allowed wireless companies specifically to attack local ordinances that they felt were restrictive. In 2004, that was our most current revision to our regulations. 2005, a critically important case, Metro PCS versus San Francisco. I was the expert witness in that case. That case came up with the standard that we all use today. It's the significant gap standard. It says, the court essentially said that if a wireless carrier has a significant gap in its service, then if it proposes to close that gap or reduce it to less than significant using the least intrusive means, so it's called the significant gap least intrusive means test, then we have to say okay. That's the law that is the court-made law that is in effect today, and that shapes a number of the rules that will go into the new ordinance. So this is a critical case from 2005. In 2006, the state issued some rules on co-locations. Those rules, frankly, have very little impact on us because we were pretty lucky at the state level to water them down so that they didn't force us to do co-locations. They basically provided guidance. So it's more of a historical note than anything else. 2006, first of a series of cases, Sprint versus La Cañada Flint Ridge, talked about what is the authority to regulate wireless facilities in the right-of-way. That's a critically important case for us, and it's the first in a series of cases. That one didn't come down very well on our side. In 2007, the tide changed a bit, and at Sprint, there were actually two cases in that. Let's see if I can get this. There we go. 2007, 2008. Sprint sued San Diego and didn't come out all that well for Sprint, which means it came out pretty good for local governments. So change in the legislative, court-made legislation in terms of wireless siting. Change in the way that we could look at wireless sites. Very important cases. 2009, T-Mobile versus Anacortes. That case amplified the Metro PCS case and basically said, if a carrier comes in and says that they have a significant gap, then the burden can actually shift onto the local government to show that what they're proposing is not the least intrusive. Let me translate that into something approaching English. Wireless carrier comes into Ojai and says, we have a significant gap, and we're going to close the gap this way. We think it's the least intrusive. Then the burden shifts to the government to say, well, it's not. You could do this or this or this. As you can imagine, and this is good law today, as you can imagine, it places a burden on us in our ordinance to provide for like alternative site reviews. And a lot of governments have adopted alternative site review language in their ordinances that says if you're going to come in and you're going to be doing these things, don't come in and give us one site, give us 3 different options that we can select, because at the end of the day, who's the arbiter of the least intrusive means? It's not the carrier. Right. Because the least intrusive means is on the values of the local government. It's not just, for example, the smallest. There are a variety of things. So that's a very important case. But it does shift the burden to us and therefore requires us to add additional things into the ordinance. 2009, the FCC said, local governments, you're just taking way too long to process applications. So on, frankly, anecdotal evidence, a lot of hearsay, the FCC said, well, local governments, if it takes you more than 150 days to process an application for a new site, from the day it hits the counter to the day the city council makes its final decision on an appeal, if you go any longer than that, then the wireless company can sue you. And by the way, that's on a new site. For a co-location site, to add something to an existing site, that shouldn't take you nearly as long because the site's already there. So they said for co-locations, 90 days. The shot clock has a dramatic impact on us because, unlike virtually any other law out there, it effectively pushes the wireless carriers to the front of the line. You could have a huge development going on that's going through the process, but the wireless companies have special treatment because of the FCC shot clock. And in fact, not only does it say you can sue us, but it sets a window. It basically says, if you get to the 90th day or the 150th day, then you have 30 days to file a lawsuit, or else you lose your rights. So it almost forces the cell companies to either enter into an agreement with the local government to stop the clock or to file a lawsuit. So, and just to tell you what's happening at the FCC right now is that they're looking to reinterpret the shot clock to change the 90-day component to 45 days. And I'll explain why in a couple of slides. We're getting through this. You're doing great. Hang in there. There's more to come. 2009, a great case for us, Sprint versus Palos Verdes Estates. This is the case that said we as a local government have rights to control the aesthetics of facilities in the right-of-way in many cases. Not in every case, but in many cases we have the right to control the aesthetics of facilities in the public right-of-way. critically important for us. Still a good case law today. 2012, after a year's effort, the wireless industry was able to add 149 words to the Middle Class Tax Relief Act and Job Creation Act of 2012. That was one of those must-sign bills. And legislators like to talk about adding 149 words as hanging a Christmas tree ordinance on a bill. This was a Christmas tree ordinance for the wireless industry. I'll get into those 149 words and you'll see what impact they have on us in a bit. 2012, after Calabasas adopted its new wireless ordinance, Crown Castle sued that city. That case was recently decided. Essentially, if you want to give it percentages, the city won 95%, Crown Castle won 5%. So the Calabasas ordinance, which I helped to create, was actually a very, what's a good word for that? Tough ordinance. But it was upheld in large part, in the absolute majority part, by the court down in LA County. About the same time, Crown Castle also sued the town of Hillsborough, where I'll be tomorrow night, because they adopted a moratorium and Crown Castle didn't like it. They've since adopted their new wireless ordinance and their moratorium is dissolved, or will be in the next few days, so that case will effectively peter out very quickly. In 2013, the FCC said, you know what, those 149 words I was telling you about, no one understands what they mean because Congress didn't give us very much to go on. 149 words that would effectively completely alter wireless siting. Congress did it in that. So the FCC came out with a guidance in January of 2013 to tell us what they thought it meant. Well, let's see. In 2013, a bill was dropped here in the Assembly that would have been basically, it would have taken those 149 words and made it even a bigger Christmas tree ordinance. It would have made it a full Christmas tree for the wireless industry. That bill, AB 162, would have essentially taken most of our discretion for wireless siting away from us. That was dropped in by Chris Holden, Assembly member from Pasadena. The League of California Cities, CSAC, and others fought that bill, and it became a 2-year bill, so it didn't move in 2013. Later in 2013, towards the end of the year, the FCC said, well, you know, we put this guidance out to tell you what those 149 words meant. Now we're going to give you 87 pages of explanations and rules, proposed rules, to tell you what those 149 words mean. And what's happened since is that that rulemaking is currently open. Come on. And comments and replies closed a couple of months ago. So the FCC right now is chewing on those rules. But those are the rules I was talking about that could change our process time down to 45 days. If you think about it, 45 days from the time a project hits the planning counter to the time it gets to the city council, it's essentially impossible in virtually every city. Come on. And I believe personally that it's effectively to cut out the public participation because there's not even time to get notices out. But, you know, we're dealing with a very powerful industry. Thank goodness earlier this year, AB 162, which would have been a terrible bill for us, died. It didn't come out in time to make this legislative session. And I think 2014, a great case was decided in Huntington Beach. T-Mobile sued Huntington Beach over its local regulations of putting cell sites in public parks, and that one came down very favorably for the city. If you look at this chart, what do you see? What you see here is that essentially, while everything else has been happening, we've been static. That's why I wanted to present it to you in chronological order to tell you everything that's been happening external to us that affects our processes here. And again, explain to you and to the public why this process is so critically important now. We've been static, the world has been changing around us. I think the last, we went into the moratorium, and I think the last one here is that we're waiting for comments from the FCC in fall of this year. Another case, T-Mobile versus San Francisco, just came down a couple weeks ago favorably. All right, I have taken up enough time on this slide, but this gives you the framework of what has happened in the world outside of Ojai. I know many of you think that there's no world outside of Ojai, but it turns out there's a heck of a lot happening. Here are the 149 words. This came out as a Christmas tree ordinance in 2012. And to tell you essentially what this means, it says, if there's an existing cell site and someone wants to come and add equipment to it, change equipment, modify it, if it doesn't substantially change the physical dimensions of the site, we must say yes. Not only must we say yes, just to make sure that there's no misunderstanding, the specific words are that we may not deny and shall approve. So in case we were going to deny but not approve, no, it's we may not deny and we shall approve that type of modification. Why is this important? Think back to the slide I had at the beginning showing you the cell site that's here in town, right at the AT&T monopole, the faux tree. If someone wanted to come and add equipment, change equipment, things like that to that site, that's specifically what's covered by this rule. So essentially, when you're putting in a new cell site, you have to think not only about what the cell site is that's going in, but what could it morph into? Good question. I'm glad I asked that. So the first issue is, before we even get to that, notice right, and I'm going to try and point it here. Let's see if I can do that. Can't really do it. If you look at the first sentence under Section A1 in general, notwithstanding Section 704 of the Telecom Act. Remember I showed you the slide earlier that says that's our basic federal authority? Notwithstanding our basic federal authority, so essentially that whole section is nullified by those 149 words. What is nullified by it? Well, it presumptively would also preempt local ordinances. Since it says, and let me go back to the actual words, because it's really important to read that and why we're going to deal with that. Notwithstanding Section 704 of the Telecom Act of 1996, or any other provision of law. What's another provision of law? State law, City of Ojai ordinances. Right. This is about as broad a preemption as you get. There are a number of constitutional issues that will be dealt with in this particular statute, but that's probably about 5 years off. Most of the municipal attorneys take the position that if there was ever a on its face unconstitutional 10th Amendment case, this is it. But again, 5 years out. And until those decisions come down, we can't ignore this, so we have to deal with it. So moving forward, that X's that whole section out. This is a cell site in Denver, Colorado. I do work in the Denver area. It's a mono flagpole. Most people would look at that and think, okay, that's probably pretty in character with the shopping center. Under Section 6409A, plain reading of it, this is what could happen. It's called a drop and swap. And why would a carrier do that? Well, it's because in a mono flagpole, because of physical dimensions, it limits the number of antennas that can go into it. That's why those 149 words really are important to us, and why we have to craft to do the best that we can that talks about what is a substantial change in the physical dimensions. It turns out Congress said if it's not a substantial change in the physical dimensions, we may not deny and shall approve. but it didn't tell us what a substantial change is. That's part of the 87 pages the FCC is currently dealing with, is to try and tell us what Congress meant. Just for the 149 words, there was no floor debate, there was no legislative history. There's just no guidance at all. That's why the FCC is coming in to say, well, we're the arbiters of the Congress in this area, so we're going to tell you what we know they meant. One of the reasons why your city attorney and your city manager recommended to you to go into the moratorium was specifically because of this section of Section 6409. And it will drive, in part, the timing. I'll talk about the timing issues as we go further. I'm going to show you some pictures of things that we're trying to avoid in the new ordinance. Well, as you can see, this is clearly a monopine antenna. I like to say of this picture, this is actually at a Caltrans yard in West LA, pretty close to my office. I like to say, if you have a faux tree, can you have a faux tree disease? And clearly the answer is yes. This site has recently been upgraded, but I keep the slide in because for a long number of years, this was considered to be a camouflage wireless site. I think one might argue this is not camouflaged, but camouflage is going to be a big element in terms of the new ordinance. This is what we're trying to avoid. We're also trying to avoid this, naked sites, monopole sites. This is what we have, and I will tell you, in the grand scheme of things, this is not a bad-looking site. I've seen far, far worse in the past. The convention, by the way, now is to put the antennas a little bit lower and to have the branches come out. So we'll talk about aesthetic standards in the ordinance as well. But on the grand scheme, again, this is not a bad site. Here's a wireless site in Thousand Oaks, as you can all see, correct? It's completely camouflaged up above the Sharkey sign. This is a good goal. These are the type of things that most communities want to try and encourage are camouflage sites that don't change the aesthetics of the community. This is a FM broadcast station in Thousand Oaks, as you can all clearly see. Why do I have this picture in? Well, first off, a good wireless ordinance will deal with all sorts of wireless. I talked about that at the beginning. And this is an FM broadcast station. The station itself is physically underground. I'll have to get up and point it out to you. Sorry. Nope. So right about here is an underground room. Open it up, walk down into it. That's the transmitter location. And the antenna is up there, the water tank is just that little stick antenna. Why do I want to show this to you? Because it's an open space. And while there's a general aversion to using open space, properly done, it can provide a suitable location for a site that's necessary to serve. And remember, since we deal with significant gap, there are times when we may have to come up with solutions. So we think it's important to think this deeply into the question. But to put I guess you could call this an underground FM station. It's fairly common to see cell sites on top of light standards in the right-of-way. The equipment itself is located underground to the right of the facility, of the pole. I took this picture last week in London. This is the travelogue portion. This is a microsite. Use the two antennas that are strapped to the light standard. And yes, the Book of Mormon is in London at the moment if you want to go see it. Here's another type of site. This is the size of a home wireless router. So we're talking about 6 to 8 inches with short antennas. This is how wireless service is provided in central London. And essentially, there are many of these around the city, but they're very small. Reason I bring this up is because we're not allowed to regulate technology. We're simply not allowed to regulate technology in the wireless ordinance, but we can regulate aesthetics. And aesthetics comes into size, color, things like that. The purpose of my putting this slide in, and your city attorney knows this because he was at the same lecture, the current FCC rulemaking that I talked about, the wireless industry has said that a small cell is one that is 17 cubic feet or smaller. No one has ever accused me of being small, but I'm smaller than a small cell under the current FCC's proposed definition. We'll see what the FCC says. In the county of Ventura, their definition is for 8 cubic feet. There's a right number for Ojai as well, but the purpose of setting volumetric sizes for small cells is to encourage their use, and by giving them an easier processing route, because number one, wireless is good. I mean, let's just deal with that issue for a second. A community without a vibrant wireless service is one that essentially is a second-class community. But our goal should be to have a rational deployment of wireless facilities so that it doesn't detract from the underlying aesthetics of the community. Now, I've been coming to Ojai for decades and decades. My wife and I met here at Camp Ramah. So this is close to my heart. And I've done work for the city in the past. The reason that volume is a good standard is because it doesn't deal with technology, but it deals with community aesthetics, and you'll hear a lot about that. So one of the hallmarks of the ordinance will be aesthetics. It's like talking about the wireless sites that are camouflage. What is camouflage? That's an aesthetic issue. Size of equipment, it's an aesthetic issue. So there'll be various paths. If you come in with a site that's not aesthetically pleasing, it's going to go down one path through the ordinance. If you come in one that is, and it's small or whatever it is, it'll go down a separate path. So that's going to give you a preview of the thinking of attorneys as we write things like this. So I'm just about at the end, and this is kind of to recap where we are and where we're going, and some of the hallmarks of what you're going to be looking for as we go forward. We're currently tonight at the end of the 45 days. You're going to be asked to consider extending that out to the end of a year. After that, there's actually one additional year that's possible. Hopefully, we'll have our regulations in place for you to adopt very quickly after the FCC acts, and you won't have to take the entire time from the moratorium. Because again, while the moratorium's in place, wireless expansion in Ojai is basically frozen. Talked about that. Under the Telecom Act, if a site meets the FCC rules, we can't deny the site based on RF concerns. That's just kind of a hallmark of both congressional law and the way the courts have interpreted it. So we'll talk about it, but only a little bit in terms of complying with federal law. But that's important to understand because as we're aware, the public has concerns about RF safety. So this is going to be an educational mission as well. So the process going forward is to have meetings, because this is something that attorneys write, but it has to reflect the needs of the city of Ojai. So the normal process is to have 2 or 3 meetings with the public, and separately to have 1 to 2 meetings with the wireless carriers. Why separately? Because everyone needs an opportunity to have their voice heard without going into fights, and the bottom line. So by having the groups, those who are regulated and those who want regulation, to have their opportunities to speak without interruptions or debates. It's important for us to hear what each side needs It's also important in terms of creating a good legislative history for how did we come up with the ordinance that is in Ojai. Any good attorney, and I believe you have two of them sitting at the front of the table here, will tell you that when you do this work, you always keep in your mind that a judge might review it. Now, that's not the reason why you do it right. You do it right because you want to do it right. But you also keep that in your mind, is that you want to be able to defend the process. So getting the public's involvement and separately getting those who are regulated, getting their input will be very important to making this a good process where, if we're lucky, everyone will have things they love about the ordinance and everyone will have things they hate about the ordinance. There will be some critical definitions that we'll wait for from the FCC. It's one of the reasons why we can't really get this done before the fall. But this gets back to Section 6409, again, those 149 words. What is a base station? What's a wireless tower? What's a substantial change? Those are key. We can figure out what those are for Ojai, but it's important to understand that even when the wireless ordinance is done, and it goes to PC, and PC gives its recommendation, then it goes to City Council acts on the ordinance, probably a year later, it's going to come back. And it's going to come back for true-up purposes. There's always going to be tweaking. Staff will come up with ideas on how to make it a little bit more vibrant, changes in law. So I'm telling you this now because I don't want it to be a surprise in a year or two from now, because we will come back for a true-up, and then it'll be stable for probably a substantial period of time. I'm not going to even go through any of this right now. That's all process stuff. Talked about that already. So this will be like a standard ordinance where it'll be a two-reading process. We'll bring it to the City Council when it's gone through Planning Commission. They've made their recommendations. We'll bring it to you. We'll ask you to read it, and then 30 days later to read it a second time. At the same time, we'll also ask that upon the effective date of the new ordinance, that you dissolve the moratorium. So it all kind of happens at that magic instant. Not quite like the pink moment, but similar to it. And I do believe I have talked my ear off. I appreciate you listening. I've given you a heck of a lot of information, but I've hopefully given you why we got here, what's happening around us, where we're going, and how we're going to get there. That was my goal, and I hope I've achieved it. And with that, I'd love to get your questions and questions from anyone else.
Council members or commissioners have questions? Mr. Kramer?
I have a question. All this discussion was about facilities in the right-of-way. This recent thing that we had was on actually private land. So does that change any of the regulations at all?
The ordinance that we will bring to you will deal with both. There are actually three different types of properties in the city of Ojai. There is private property. The church is an example. There's public property, this building, and there's the right-of-way. Each has to have a separate type of regulation. The two that are very similar, obviously, are private property and public property. The one that's different is the right-of-way, because there is a state overlay. It's PUC code 7901 and 7901.1. So we will respect those codes in the ordinance, but we will not simply bow to them.
Thank you.
Any other questions? Okay.
So I have a couple questions. First, can a small cell site morph into a monocell site?
Under the regulations that we will be crafting, it will be not by local regulation. I'm hedging my words here because, as you've already seen, we are at kind of the bottom end of, or the end of the feeding chain. At the top is the federal government. Above us is the state. So we will do what we can locally to make sure that doesn't happen. And we'll do that by talking about what is a substantial change in physical dimensions. But I can't make you a guarantee that a small cell site won't morph into a big cell site later.
Okay, and then my other question is it from your timeline, it doesn't look like the FCC health and safety rules have been upgraded since 1996?
Thank you for allowing me to fill a hole in that big slide. The FCC actually has a separate rulemaking going on right now to go back and review whether their rules are still appropriate. That comment period is closed. I was actually invited by the commission back last July to revise the federal government's guidance to local governments on that subject once they come out with the new rules. It's my belief, based on the notice of rulemaking, that they're not going to change it. The reason why it's unlikely they're going to change it is because of the safety margins that are built into the current rules. You've given me a perfect segue. If the council and the commission will allow me another 2 minutes, let me talk about this issue in a little bit more detail. I actually had a slide just in case the question came up. So let's talk about the FCC's rules. These are the rules that have been in effect since 1997. And I could give you all sorts of technobabble, but I'm going to give you a 12-inch ruler instead. So if our 12-inch ruler, if the top of our 12-inch ruler is the point where you could actually measure a change in the human cell because of RF, we're going to put that up the 12-inch mark. Come on in, folks. Okay. So the question is, on this 12-inch ruler, for the general public, where does the FCC set its standard? Anyone want to guess on this 12-inch ruler where their standard is? 1 inch. Any other guesses? Well, the answer is it's down at about 1/4 of an inch. So it turns out there's a 50 times safety margin built into the current rules. Now the question that always comes up is there better sciences? Two questions. Number one, is there better science? And number two, what about other countries? Where do they set their standards? As for better science, there have been a tremendous number of reports over the past 16 years that have come out. But if you look at the peer-reviewed ones, the ones that are repeatable science, they all come out basically saying, yeah, if you look at frequency and power levels, you can figure out what affects people and what doesn't. We're bags of water. We're bags of water. And because we're bags of water, we absorb signals more efficiently at certain frequencies than at others. So the FCC rules today actually aren't a single straight line number. The actual FCC rules, and again, this is why I wanted to do a ruler, because it's accurate for this representation, essentially says that at those frequencies where we are most susceptible to RF, that's where the rules are the most stringent, the lowest numbers. And at those frequencies where RF doesn't have the same impact, higher levels are permitted. So the bottom line is, for absorption purposes, I'm sorry?
Does that sound counterintuitive?
Well, it recognizes the fact that where we're not susceptible to RF, higher numbers are appropriate because it just doesn't have an interaction with us. Where we are susceptible to RF, that's where the FCC has its most stringent standard, its lowest permitted standard. And that's what this is based on, is the lowest permitted standard. And as a practical reality, most wireless carriers operate at fractions of 1% of the maximum allowed by the FCC. Why is that? It goes back to the second slide I had, the first slide I had, that showed the multiple cell sites together. It's because if you have high power, it causes interference to adjacent cell sites. So as a network grows over a period of time, the power level from each cell site goes down. And that's just the reality of how networks are designed. So this is the slide that explains the current FCC rules. And this also explains why I don't believe the FCC is going to change its standard. The standard in the US is a 50 times safety margin. Other countries have different safety margins, and the FCC has said, you know what? It has no effect, whether it's 20 times or 70 times. If there's no effect, then there's no effect. So I believe that when the FCC does come out with its rules, it's going to say essentially, the standards are still good standards today, and we'll come back and revisit them again in the future. That's the answer.
So who funds the studies, or what institution generates who do they look to do the science?
The FCC went out back in I'll talk about the current standards. They went out to the wireless industry. They went out to radiological health officers. They went out to other government agencies. They essentially did a broad survey of the standards that were out there. They looked at the scientific community. So this wasn't a standard that was developed by a single entity. It was essentially a consensus standard.
So just last question. So because they feel that they have adequate guidelines,
Probably.
that they feel that, therefore you can't use health or safety as a reason to block an applicant.
Under Section 704 of the Telecom Act, if a wireless carrier proposes a site that's compliant with the FCC rules, we may not base our decision on health or safety concerns.
But because it falls within this.
If it falls within this, if it does not exceed the 0.24 inches standard, then we're not allowed to base any decision on RF safety. That's a bright line test that's been upheld by courts around the country.
Any additional questions, council members, commissioners?
Can you speak a little about the future of the small cell technology, how it relates in power to the large mono cells we're seeing? Is that something that's going to, down the line, take over, or is that, how does that work?
When you mean down the line, you're talking
well,
about
in years.
summer.
In 2 years, are we going to be able to unload the larger cell towers in lieu of the smaller ones that we see on the lampposts, that sort of thing? Is the technology changing that rapidly?
This is May. Later this summer, Verizon and AT&T will be dropping several thousand applications into Southern California communities to deploy small cells. The first wave of small cells is coming this summer. In terms of what they are, they're small cells. They're meant to cover very small areas. And you cover small areas by having low power. So where a big site might use 20 or 30 times the power of a small cell, physically the small cells are smaller. The ones that Verizon talks about they say they're roughly the size of a briefcase. They're larger than the pictures I showed you from London, but they're a heck of a lot smaller than the sites that we see going in today. They're meant to cover very small areas. And again, the purpose of it is to reuse those frequencies to add capacity. The holy grail today are, number one, adding capacity, and number two, providing in-home service. The wireless phone companies already know that more users use cell phones than use corded phones. And that's simply going to continue. That trend upward's going to continue. So providing that service into residential areas is critical. We cannot prohibit a wireless company. We can't just come up with a standard that says no cell sites will be allowed in an R zone. The reason is because if there's a significant gap, and the only way to close it is going through an R zone, then the courts have said we have to do that. So the standards that we'll be tailoring as part of the ordinance will address that, and they'll say, if you want to go into R zone, that's the highest burden of proof. You have to show that no cell site outside of the R zone or combination of cell sites could provide you with a way of closing it. The federal government does not guarantee the wireless company the ability to close a gap with the least costly solution. It's the least intrusive solution. And again, that's why it comes back to us, the city, to make those decisions as to what the least intrusive is, as long as what we're doing is not such a great burden as to effectively prohibit the deployment of the service. So when we talk about the standards, we talk about a safety valve, not a prohibition. I'm glad to see you nodding. It's good.
Any other questions from council members, commissioners? Anyone in the audience want to ask any questions? See none. Meeting adjourned.
Thank you very much.